Before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blasier, Mr. Neufeld, Mr. Scheck. People represented by Ms. Clark, Mr. Darden, Mr. Yokelson, and Mr. Harmon. The jury is not present. First order of business, counsel, I scheduled the hearing on the prosecution's motion to admit certain testimony concerning the defendant's activities, I guess is what we would call it, on June the 17th. That hearing was set for 8:30 this morning. Court was here, defense counsel were here, defendant was here, and we were ready to proceed. The prosecution did not choose to appear in court until 9 o'clock. Is there an explanation for this?
Yes, Your Honor. The person designated to argue this segment of the case had an emergency at home and was unable to make it, and I apologize to the court. But the time has not been wasted. I have been in conference with other members of the team. At this time, Your Honor, we'd like to indicate to the court that we will not be asking to admit the events of June the 17th at this time. However, I repeat at this time because we have not yet heard the end of the defense case. We have not yet heard Sir rebuttal, and I would like to reserve the option of asking to renew our request to admit that evidence depending on what we see in the balance of the defense case in chief and Sir rebuttal.
All right.
We are trimming this case so that we can get it to the jury, and we are hopeful that we can rest the people's rebuttal case tomorrow.
All right, Mr. Cochran, as to the withdrawal of the June 17th witnesses.
Yes, well, we certainly accept that withdrawal. We think it's appropriate, saves you having to waste your time on that. And we accept that, obviously, Your Honor, no problem. I'd like to raise a couple of issues, if I might, Your Honor.
All right, well, we're not finished with that yet.
Okay, certainly.
All right. The offer is accepted. However, the failure to appear in court in a timely manner and failure to advise the court, sanction will be $250 to the district attorney's office. That's to be paid by the close of business today. I'm more annoyed.
May I remind the court that Mr. Shapiro kept the court waiting for 20 minutes, showing up at 20 after 9 when it was his witness on the stand, and suffered no sanction?
Thank
Sure.
you. Sanction will be $1,000.
How much?
1,000.
Okay.
Next
Your
question.
Honor. Fine. May I proceed right now? Your Honor, with regard to, at the end of the day yesterday, Your Honor asked us not to waste your time. Ms. Clark, on the record, indicated certain witnesses. You'll recall she said people like the modified Thanoparatus video, which you talked about, and the Diedrich and Bodziak and the Bronco fiber issue and the Ackards and all those kind of things. And you said, don't waste my time, get together. Mr. Douglas went over and talked to Mr. Darden, who told him, I don't know who we're going to call. They gave us no proffer, no offer of proof, no cooperation, no nothing. So we don't want to waste your time, Judge, but when they won't talk to Mr. Douglas, what are we going to do? So the problem is, and they said they don't know who they're calling. If, Judge, they are saying they're going to finish this case by Thursday or by Friday, then we're entitled to all the rest of their witnesses. We're entitled to the end of the witnesses. And all we're trying to do is get somebody to talk to us so we can resolve this matter. We want to resolve it. If they really want to get this case to the jury, we'd like our proffers. We'd like to know who they're really going to call. Now the 17th is now out, and that's fine. And so we'd just like to have, would you direct them to meet with Mr. Douglas right now so we can get this done, Your Honor?
I met with Mr. Douglas. Good morning, Your Honor. I met with Mr. Douglas yesterday afternoon. I gave him approximately 6 names that included Sims, Diedrich, Bodziak, Lawrence Ackert, Nancy Ackert. What other names did I give you, Mr. Douglas? I don't know what he's talking about. I've given him the names.
No. Mr.
Okay?
Douglas can speak
I
for
gave him the
himself.
names. If Mr. Douglas says that that isn't correct, he was writing on his pad. I was standing right here yesterday late afternoon. If that isn't true, is that true?
I asked him what order is going to be called following Sims. Mr. Darden said, I do not know. I asked him this morning. He gave me these names. I asked, what order, who's next after Sims? This morning, he said, I do not know. If I'm mistaken, please correct me.
Right. But he gave you the witnesses. He's given you 5 or 6 names, correct?
He did, Your Honor, and I asked who follows Sims so that I can have the person who does that witness ready after Sims.
So, in other words, Your Honor, what we're saying is she gave us some names in court, but we want to know who's up next, what's the offer of proof.
They've given you the names. We know who Bodziak is. We know who Sims is. We know who Diedrich is.
I can tell you this about the Ackerts. We're trying to get the Ackerts here from out of the country to testify tomorrow, so they won't be here today.
All right, testify as to what?
Heitstra issues.
Heitstra, okay.
Your Honor.
And they have the discovery in that.
All right, Your Honor, and may I inquire, are they still planning to rest then by tomorrow or Friday? Because then we would be entitled to anybody else they have. It's within the 3 days, and we're just trying to find out who
Well, I
else they have.
assume that's their case. They tell
right.
me that they're going to rest tomorrow or Friday.
All right, that's fine then, Your Honor. The last thing is, Your Honor, the next thing I'd like to, we're going to have to address at some point this Bronco fiber issue, which we think shouldn't take the court very long. Speaking of no-brainers, but we're ready to do that whenever you want to. The last thing is, we would like to have Agent Martz, FBI Agent Martz, back here, need this court's assistance for, if they're going to rest truly on Thursday or Friday, for our case on Monday, September 18th. We'd like to request that now, so we'll have him here. In addition to that, we expect to call Special Agent Whitehurst of the FBI, and we expect that hopefully Mr. Scheck has started a procedure by which hopefully justice will make this person available. He's a critical witness in this case, and it'll tie in with the March testimony, so that there's no delay in that regard.
All right, if there are any interstate subpoenas that need to be issued, submit them to Mrs. Robertson
All right.
as soon as you can.
Thank you. May I have 1 second? Your Honor, so we're trying to save downtime. We will work on that today. The last thing is, Your Honor, on this whole issue, if the Ackards or anyone's call with regard to Robert Heistra's testimony, we need Detective Dennis Payne, who we understand is retired, and we want to put him on notice now. We need Payne if he's out of...
Is Payne the one who took the
Yes, he took
statement
the
from
statement.
the Ackards?
From Heitstra. No, from Heitstra.
From Heitstra.
Heitstra. And we need
Okay.
him right away, so we need your help, and we want to put him on notice. We want Payne, so there'll be no downtime on that as soon as possible. Might as well have him here Monday.
They should contact the LAPD. At any event, they marked Mr. Heistra's statement. I'm not sure, but I think you admitted it in the evidence.
We want Dennis Payne, Your Honor.
Well,
So that's the issue on that.
they
All right.
call the LAPD.
Then you're not willing to make him available?
He's retired, Judge. I can't make him available.
All right, you'll have to subpoena him.
You get an address or something, Your Honor?
Penal Code section that would preclude us from giving them the address of the retired police officer.
All right, well, counsel, what we'll do is, I don't care about this fight between the parties. I'll have my staff contact the LAPD and make them
Thank you, Your Honor. That's
get
all
their
we're asking.
cooperation to produce him.
And producing for Monday, Your Honor. Thank you very much.
Well,
Or soon thereafter.
he's retired. He could be in Florida. Who knows?
Well, we'll try to, as with the other witnesses, we don't want to delay this trial. We pay for him to come back.
All right.
Your Honor, with respect to Agent Diedrich, if I understand it correctly, he's supposed to be here, arriving here at 12:30, the last representation, and Mr. Morton is going to be able to get here at 12:30, 1 o'clock. I at least would like the opportunity to look at the underlying data from the report that they just gave us. I do get that
I issued that
opportunity.
order yesterday.
I understand
That
that.
as soon as the exemplars or the impressions are here, you're entitled to look at them, to see them. You're entitled access to that. We dealt with that issue yesterday.
No, I understand that, but just wanted to make clear we're going to get that opportunity, and that includes the jeans, the envelope, the shirt.
The whole enchilada.
Well, all right. I just want to put, in terms of scheduling, I want to put the court on notice, and
All right.
Your Honor, we need to, number one, we need to be heard with respect to the admissibility of the Whitehurst issue. And we're prepared to argue that so that we do not waste time trying to locate a witness who I believe has testimony that has nothing to do with this case and is irrelevant. So, we're going to go into downtime to make him available when he has no admissible evidence. Secondly, I'd like to argue the Bronco fiber motion.
Well, let's do this. Let's proceed with your next witness this morning with the jury, because the jury's expecting testimony now. As soon as we complete that phase of your presentation, where do you anticipate going after that?
Well, we had wanted to go with the Ackards since they're not available immediately. I would like to, we may have a little downtime because we have to fly witnesses in. The Paratus tape presented with the testimony of Steve Oppler, and we have, which we've edited and we'll show to the court. And Then we would intend to call Doug Diedrich, any fiber witnesses that we're allowed to call, and Bill Blasier. But they won't be ready for testimony until tomorrow morning. So we might have...
All right, so then the point of my asking you that question is that we don't need to resolve that issue now. If there's going to be downtime for witnesses, we can use that time to argue the motion.
Well, the problem is I don't know whether to notify the witnesses to come in or not until the court rules.
Where are these witnesses coming from?
Washington, I believe. They're flying. They're not in the state.
Okay.
And I didn't want to fly them out if the court was going to... I mean, they're on standby. I have them on call, but I'm not going to spend the money to have them out unless you say...
All right. Mr. Cochran, who on your side is going to argue the Bronco fiber motion?
I believe it'll be Mr. Blasier.
All right, are you prepared?
Yes.
All right, I'll hear the argument.
I believe we're the moving party, Ron.
Yes. I just wanted who was, if they were ready, you're ready?
I'm ready. They're ready. As my moving papers have indicated to the court, we believe that the evidence is admissible and proper rebuttal for two reasons. First of which is, I believe we appended to our motion the transcript sections from the testimony of Kathleen Bell as elicited by Mr. Bailey, in which he gratuitously asked her questions concerning the kind of car Mark Furman drove, or she believed he drove, back when the statements were made. There was no purpose, no legitimate purpose for asking that question unless it was to, other than the one we're arguing they were trying to infer, unless it was to show that she in fact did know him and therefore could identify him. That argument, however, falls as specious because there was never an effort to link up the car she described to any car known to be driven or owned by Mark Furman, which could have been done through DMV records or any other people who knew him at the time, including the police department. No such effort was made, and it is clear that the motivation for asking those questions and eliciting not once but twice that she saw him driving a sports utility vehicle was to have the jury infer that he preferred that kind of vehicle and therefore the fibers could have come from that vehicle. And as the court recalls, Mr. Bailey was the one who handled the hair and fiber evidence with us and is most acquainted with the issues concerning the admissibility of the Bronco fiber study that was conducted by Agent Diedrich. That's on one hand. Secondly, with respect to the attack on Mark Furman's credibility, as the court is aware, an all-out attack was launched on his credibility and has become the cornerstone of the defense case. Anything in the case in terms of scientific or objective evidence that tends to indicate that the glove was not planted and that he was not responsible for the planting is naturally relevant as a rebuttal to that claim. Having found Bronco fibers on the Rockingham glove, and that's key. It's not the Bundy glove. It's the Rockingham glove, and that's the one they're claiming was moved. That is key to establish that, in fact, it was not planted because the fiber on that glove came from a rather unique source, not just any car, which is what otherwise they could argue, or even any carpet in a house, but a very unique fiber that was made during 92 and 93 and put into 94 vehicles, a fiber whose configuration in terms of the cross-section and the dye formulation was changed later in 94 and had not been made prior to 92. Moreover, this is a fiber in which carpeting was used for only three kinds of cars, predominantly for the Bronco, more secondarily in much fewer number, Econoline vans and F-Series trucks. So you have very highly probative evidence found on the glove that could not have been planted, that would tend to rebut the claim that the glove was planted by Detective Furman. So we have two independent bases on which to admit this evidence now, which makes it proper rebuttal. People have cited the cases to the court that indicate why this is admissible rebuttal and why it is proper to address this at this time. The court is aware, of course, that the discovery has been given to the defense on this, so there's no element of surprise here. The witnesses that would be called to prove this evidence would be two, at maximum three in number, of very short duration. One, to talk about the fact that the fiber of this cross-section was made during these years, sold to Masland. Masland representative will say that fiber was put during these years with this dye formulation into these cars. And that's it. And then Doug Diedrich to say, and that's the fiber I saw. That testimony collectively for all three witnesses should not take an hour. So we are not talking about an undue consumption of time either, but I do think it is highly probative and certainly important to rebut the claim of any evidence movement by the defense, especially the Rockingham glove.
Mr. Blasier?
Good morning, Your Honor. As the court will recall, I believe it was with Susan Brockbank, I asked a series of questions about whether they had checked other vehicles. And I asked those questions based on representations that had been made to us by the manufacturer of this fiber that it was very, very common. Unbeknownst to me, that same person, the actual person that we had talked to, had already provided written documentation to the FBI as part of their investigation of the source of the fiber that they titled it. That was just completely the opposite. And it was only after that point that Mr. Dietrich came in and brought his paperwork. I asked him a number of questions before he testified to try and find out what he had, and he was very, very evasive. Finally, the court had to intervene and make him have a copy of his whole binder made. And in that binder is this very, very detailed report where they had done a thorough investigation months before. I think it was a 7 or 8 page report titled The Source of the Fiber. And the court, properly so in our view, precluded the prosecution because of misconduct from putting on any of that evidence because it had been held back and not turned over in a timely fashion prior to our conducting our cross-examination of these witnesses. We were extremely careful after that point to not ask a single question about rarity of Bronco fibers. We didn't ask anybody about that because we did not want to open the door. Now, as I understand the argument, well, first of all, I think it's interesting that Ms. Clark has argued many, many times that there's absolutely no evidence that Detective Furman planted the glove. Now she feels the need to bring this evidence in to show that Mark Furman's carpet fiber is not on the glove. We have never said that. We've never maintained that. The references to his green utility vehicle were it was obvious what the purpose of that was. It was to demonstrate that Miss Bell recognized his car and had seen that same car with him in it on a couple of other occasions. If the prosecution is concerned that we would argue that the car that Mark Furman drove in 1986 might have a fiber that matched the fiber on the glove, they can put on a witness to say what kind of fiber was in Mark Furman's vehicle. That would certainly solve that problem. That's not the reason they want to do this. They want to do this because they think that was powerful evidence. It was precluded before because of their misconduct, and now they're trying to find a way to get it in. This is just a ridiculous argument. And we haven't offered any testimony about what vehicle Mark Furman drives. We don't intend to. We would never argue that. That's a ludicrous inference. It's not believable. It's not a justification for putting on this evidence that was wrongfully withheld before.
What do you think about a restriction if I maintain the preclusion, a restriction on argument as to the rarity of the fiber and the lack of evidence thereof?
Well, if they're allowed to put on evidence about the rarity of the fiber, then the preclusion, the effect of the preclusion is nil. I mean,
No, you misunderstood my comment. If I maintain the preclusion, that's likely to include a preclusion of argument.
Oh, absolutely. That's no problem. We don't intend to argue that.
Maybe just a second here.
Stated in the record, I assume, is what you mean. We don't have any problem. We're not going to make any argument that we know is misleading based on information they've obtained. I have no problem with that. I assume that's what you were suggesting.
I'm just asking.
Yeah, that's fine. We didn't plan on arguing that anyway. We don't want to do anything improper in closing that might allow them to come back and ask to have the case reopened. That would be foolish.
All right, thank you. Ms. Clark.
I don't know why they're trying to hide the truth. Doesn't the jury have the right to the very best evidence that exists? we have evidence that is very powerful, that is further evidence of the defendant's guilt, and to simply preclude them from arguing that it was Mark Furman's vehicle does not go anywhere near addressing that issue. Furthermore, if there is to be a preclusion in the alternative, Your Honor, then the preclusion should include their ability to argue that any police officer's car could have imparted those fibers, because that is in fact the case, and that would in fact be the testimony.
I accept that. I mean, I assumed that what you were referring to, we would not make the argument that it could have been in any police car. We would not make that argument.
All right. Thank you,
think-
counsel.
Your Honor, I just think the rarity of the fiber is very probative evidence for the jury of the defendant's guilt. And I think that given the nature of the attack in this case and the arguments about planting of evidence, it becomes even more probative. And I think it's evidence that the jury should hear.
All right. Thank you, counsel. The reason for the court's initial preclusion was the failure to disclose the report, which gave indicia of extensive investigation as to the source, nature, and rarity of that particular fiber. That information was not turned over during the course of discovery as required. The court felt that preclusion at that time was the appropriate sanction. The proffer at this time is that Kathleen Bell testified that she observed a pea green utility vehicle at the Marine recruiting station at a time that coincided with Detective Furman's presence at that location. She then testified that she saw Detective Furman in a business establishment in that same general area, and that on another occasion also saw the same pea green utility vehicle at that location and chose not to enter the location, fearing that Detective Furman was again there and not wanting to reacquaint herself with him at that time, given the nature of her testimony. These events occurred in 1986. There was no contemporaneous testimony indicating that Detective Furman had any contact with the same vehicle. The testimony was that Detective Furman drove to the Bundy location in a police vehicle with Detective Phillips. The proffer has no probative value, and the court's previous ruling stands. All right, let's call our next witness.
Just one quick.
Yes.
All I ask is, I was out of the room for a moment when I heard that they wanted to do the Paratus tape next. All I'm saying is, in light of your instruction yesterday that they edit it, I haven't seen the edit yet. I would just ask
No,
that
I indicated to you we were going to look at it one more time before it's played. I want to see the edited as well.
Right, because I may have objections about that. Thank you.
All right. All right, Deputy McNair, the jury's upstairs still. All right, we're going to proceed with the next witness, who I take as Mr. Sims. All right, while we take the recess to bring the jury down, I had to pull a number of the Bronco exhibits for the purpose of reviewing last night. Mrs. Robertson has them available. Get your exhibits organized. Let's not lose any time fumbling with exhibits.
I need it.
All right.
Nice.
All right. We'll take 15 to bring the jury down. Get your exhibits in order. This one down for a moment, please. Since I need to see the eyeballs of the jury from time to time. As the case may be. All right, Deputy McNair, let's have the jurors, please. and gentlemen, please be seated. All right, let the record reflect that we've now been rejoined by all 14 members of our jury panel. Good morning, ladies and gentlemen. Better. All right, Mr. Harmon, you may call next witness.
Thank you. Morning, ladies and gentlemen. Morning. People recall Gary Sims.
My name is Gary Sims, G-A-R-Y-S-I-M-S.
Thank you, Your Honor. Mr. Sims, have you conducted additional testing that you're here to provide the results on in this case?
Yes.
Okay. And just to put the additional testing in context, I'd like to put up a couple of exhibit boards, People's Exhibit 260 and People's Exhibit 172, which are the Bronco photo board, or the Bronco result board, and the Bronco photo board, respectively. And start out by just briefly discussing items 31, 303, 304, and 305 that you previously presented to the jury. Item 31, if you look at the result board, that was from the center console shown in one of the photographs, and you provided some PCR results from that. Is that correct?
Yes.
And would you just summarize what the results were and what your conclusions were without addressing any statistical aspects of those conclusions?
Yes, for item number LAPD 31, which is our item number DNA 18, the DQ alpha finding indicated a main type of 1.1, 1.2, a minor type of 1.3 and 4, and those alleles are consistent with a mixture of the defendant, Mr. Simpson's blood, and Mr. Ronald Goldman's blood. And then on the D1S80 results for that sample, that the call on that was 24,25. Again, that is consistent with this same mixture.
Okay, and would you give us the same summary with respect to item 303, which was from the center console as well?
Yes, item 303 was our number DNA 52. The DQ alpha type on that was a 1.1 with a possible 1.2, 1.3, and 4. The D1S80 type was 24-25 with a weaker 18 allele. That particular mixture was consistent with a mixture of the defendant, Mr. Goldman, and also Nicole Brown.
What about 304?
304 was the same results. That was our item number 53, DNA 53.
Same as 303.
That's correct.
And what about 305?
305, in the case of 305, there was a slight difference there in that the DQ alpha type was called a 1.1, possible 1.2. The minor type in that case was a 1.3 and 4.
And what conclusion would you draw about possible sources from among the three parties whose reference samples were provided to you in this case?
Well, I would also supplement that the D1S80 results were the 24 and 25 alleles along with the weaker 18 allele. So again, that was consistent with the mixture of all three of the principles in this case.
Okay. I want to ask you a general question with regard to your PCR processing of each of these console samples that you've provided a summary of your results on. Were any of those console samples ever extracted in the presence of any of the reference samples during your handling of these samples in this case?
No.
Okay. Are you familiar with Dr. Gertie's testimony with regard to some of your results in this case?
Yes.
And what's the basis of your familiarity? Have you read excerpts of his testimony?
I listened to some of his testimony when I was monitoring it. I also have read some of the transcript.
And have you also been provided with a copy of a defense exhibit in this case, defense exhibit 1309?
Yes, I believe, is that the, I'm sorry, could you explain which one 1309 is?
Well, once you take a look at it, it appears to be a photo of a set of DQ alpha strips. Why don't you take a look at the photo in the left-hand corner and see if you recognize the photo of the complete set of strips, like the work that you did in this case.
Yes, I do.
Could you briefly summarize, and I want to solely ask you to focus on LAPD item number 31, the center console item that you just provided us a summary of your results for. Could you describe, based on your reading of Dr. Gertie's testimony, the nature of his concerns about item 31, and solely with respect to the DQ alpha testing?
Objection to summarizing the testimony.
Rephrase the question.
Sure. What are the concerns that Dr. Gertie's expressed with regard to item 31?
Same objection.
What's the first concern?
What is the first concern that Dr. Gertie's expressed with regard to, specifically with regard to LAPD item 31?
The concern that I was aware of was the determination as to whether or not that 1.3 dot was in fact a real allele showing up or an artifact. That was his concern.
Okay. Do you agree with the concerns that Dr. Gertie's expressed to this jury when he testified and discussed Exhibit 1309?
Well, I disagree with him in that his conclusion was that one could not say with confidence that the 1.3 allele was there, and I disagree with that.
And solely focusing on LAPD item 31 and the testing that you actually performed, and you're the only one that performed testing on that sample, why do you disagree with him?
Well, just for the record, I should state that this analysis was performed by Renee Montgomery, and I was the second reader on this particular date.
Okay.
I disagreed with him because of the relative intensity of the 1.3 dot in this case relative to the C dot within this particular strip.
And what's the basis for your opinion that you're correct in calling that?
Well, the call that was made at the time that this strip was developed included the findings of the 1 dot, the 4 dot, the 1.1, the 1.2, etc., the 1.3, and the all but. And the finding of these two dots, the weaker dots here being the 4 and the 1.3, was that they were of similar intensity to the C dot.
In an effort to unravel or determine the potential sources for all of the blood stains that were tested on the console, on the Bronco console, did you continue to perform testing on items 303, 304, and 305? Continue beyond what you've already described to this jury?
Yes.
And what, just generally, what did you do?
What I ended up doing, may I sit in? What I ended up doing was noting that the overall quantity of DNA that was individually extracted from those three samples, 303, 304, and 305, appeared to be insufficient for an RFLP type analysis. So what I did was to individually look at the types from those samples, and then I made a determination to combine those extracts, the extracted DNA from all those three samples, to get enough DNA so that I felt I could get an RFLP result by the collective, the bringing together of those three samples from the center, all from the center console.
We're going to talk about that a little bit, but would you just describe the relative amounts of DNA that you detected in those individual samples, 303, 304, and 305?
Yes, I can do that. I need 1 second to refer to my notes. From 303, which is our item DNA 52, there was about 40 nanograms recovered in that original extract. From 304, which is our DNA 53, there was about 29 nanograms. And then in the original extract of 305, that was around 17 nanograms approximately.
Now, why did you feel it was appropriate to combine those stains in order to pursue the RFL, or strike that? Why did you feel it was necessary to combine those three stains in order to try to perform RFLP testing to produce results from those stains?
Well, it was clear to me that we had a mixture of DNA of DNAs from different individuals in these samples. And individually, for a typical individual stain, we like to get about 50 nanograms to test in our laboratory for an RFLP analysis. And I knew that given these were weaker mixtures, that it would be very difficult to get that kind of DNA to show up on one of these autorads that we've seen so many of without having enough quantity. So the only way I felt that I could get enough quantity to do that was to combine them. In other words, I could individually test them for these sensitive PCR tests, but to get enough for one of these RFLP results, I felt that I had to combine them.
Okay, and why did you feel it was scientifically appropriate to combine those three stains in order to perform RFLP testing?
Well, I looked at this in a very stepwise fashion in terms of looking, first of all, at the consistency of the PCR results in the different systems that we tested, DQ alpha and D1S80, also knowing that they were all collected from the center console, the Bronco. I felt that, in my forensic opinion, that was the same general blood-stained area, so that it would be reasonable and certainly feasible to combine them.
In your opinion, do your RFLP results, which we will show to the jury in a few minutes, on the mixtures that you've just described for us, do they corroborate your interpretation of item 31, the center console, where you concluded that the possible sources would be Mr. Simpson and Mr. Goldman?
Yes.
In what sense do they corroborate them?
Well, the finding of those, of the RFLP patterns that are consistent with those two individuals, Mr. Simpson and Mr. Goldman, tends to corroborate the results in item number 31, which is also a center console blood stain.
Had you finished your answer?
Yes.
Okay. And in your opinion, do your RFLP results, which we'll show to the jury in a couple of minutes, do they tend to undermine the reservation or criticism expressed by Dr. Gerdes that you've described to the jury just a few moments ago?
Objection, move to strike. It's not Dr. Gerdes' testimony about 303, 304, and 305.
Leading, rephrase the question.
Mr. Sims, in your opinion, do your RFLP results from the mixtures that you've performed or that you've just briefly described to this jury, do they tend to undermine Dr. Gerdes' opinion and
What's the impact?
Mr. Sims, what's the impact of your RFLP results on the combination of 303, 304, and 305 on Dr. Gerdes' criticism about the 1.3 allele in item number 31 from the center console?
Objection, move to strike with respect to item 31.
Overrule.
Well, I think the RFLP results do tend to undermine that because they do show consistency with what I originally called on item number 31, and which Renee Montgomery also called on item number 31, namely that those DQ alpha results were consistent with a mixture of Mr. Simpson and Mr. Goldman.
Okay. In addition, Mr. Sims, do your RFLP results from the combined stains on the center console also corroborate the PCR results that you've briefly summarized from those same stains on the center console?
Yes.
In what way?
Well, again, the finding on the RFLP results is that it is consistent with a mixture of Mr. Goldman and Mr. Simpson. You'll recall that on the PCR results we saw a little bit of this 18 allele. This was the weak allele on the D1S80 results on those gels. I believe what we're seeing is that weak type that is detectable by the very sensitive PCR methodology is not detected by the less sensitive RFLP approach.
And what do you say about the remaining types that are consistent with Mr. Simpson and Mr. Goldman from the PCR? Is that what you see in the RFLP results?
Yes.
Mr. Sims, do the combined stains from 303, 304, and 305, the RFLP results, tend to address any concerns about PCR's exquisite sensitivity?
Yes, I believe they do, because we've heard extensive, you've heard extensive testimony about the sensitivity issues with PCR. The RFLP is not as vulnerable to those concerns as the PCR is.
Mr. Sims, do the mixture results from stains 303, 304, and 305, the RFLP results, tend to address concerns about potential cross-contamination among samples?
Objection. Strike. Vague or request.
Oral.
Yes, I believe they do, because to get an RFLP result, you need a substantial amount of DNA from a blood sample, particularly when you're comparing that to how sensitive the PCR test is.
Okay, Your Honor, at this time, I'd like to have marked as people's next in order a set of 4 autorads in a plastic cover. What would that number be?
Mrs. Robertson, people's next in order. 616.
616. And,
Six-
I'm sorry.
Did you want to mark them 616 A, B, C, and D?
Yes, and I'll describe, so we can correlate them later without actually marking. I'll describe the order that we'll be showing them. As 616A, the autorad is labeled D10S28. As 616B, it's autorad D4. As 616C, it's D5. As 616D, it's D2, Your Honor. Mr. Sims, I'd like to show you a set of 4 autorads, 616A through D, and would you tell us if those represent the 4 autorads that were produced as a result of your combination of those 3 stains, 303, 304, and 305?
Yes, they do.
And we've actually put labels on them that you didn't put on there to show the names and identify the stains. Is that true?
That's correct.
Okay, Your Honor, I'd like to show them to the jury and have Mr. Sims use the telestrator. I'd like to show 616A. Yeah, here.
Can we clear these artifacts? Mr. Harmon, we appear to have artifacts on the telestrator. There we go. Thank you, Ms. Martinez.
Mr. Sims, can you help get the jury reoriented on the autorad reading 1 here and describe what they're seeing so they can understand the results?
Yes, this is now an autorad from a gel which contains the combined 303, 304, and 305 from the console, and that's labeled console in that particular lane. And you recall these samples run downwards from the top to the bottom in the vertical lanes. Then we have a reference sample from Mr. Goldman, we have a reference sample from Mr. Simpson, and then a reference sample from Nicole Brown to the right side there.
Okay, and so the lane that's labeled console, that represents the combination of 303, 304, and 305?
Yes.
Is that right? And then, and the reference samples is Mr. Goldman, Mr. Simpson, Ms. Brown?
That's correct.
Could you describe your results and what your conclusions are without addressing any statistics?
Yes, the finding of that pattern in the console lane is consistent with a mixture of the banding pattern of the defendant, Mr. Simpson, and also the contribution from Mr. Goldman.
Could you, is there any way that you can show which bands match which by using different colors for the different reference samples?
Yes.
Why don't you do that?
I'll mark the lanes in the console in, I guess that's a sort of a lavender or pink color, that are consistent with the defendant's bands. And I'll also mark those lanes, I'll mark those bands in the defendant's, Mr. Simpson's lane.
And then what about there seems to be on the reference sample of Mr. Goldman for this probe, it looks like he's just got one band, is that true?
Yes, this was scored as what we call a single band pattern down in this area. It's possible that he has two very close bands in this area, but they tend to run together in all the samples that we saw in this case every time we ran his sample. It's a single band pattern. So instead of having two bands, he just has one that's scored. And I'll mark in green his position in his reference lane, and now I'll mark that band also in the console lane. The other thing that's significant to me in this particular mix is that,
Excuse me, Counsel. Not responsive to a question.
Is there anything else that's significant to you in this particular mix?
the other thing I wanted to mention, and we'll see this as we go through the total picture of these different autorads, is that the bands that are consistent with Mr. Simpson's sample are consistent with the stronger bands in the console lane, whereas the bands that are consistent with Mr. Goldman's sample, his reference sample, are consistent with the weaker bands in the console lane.
And is that true with each of the 4 autorads that we'll be showing to the jury?
Yes.
And does that somehow relate to the amounts of DNA in those, in your opinion?
It relates to the relative contributions from each individual.
Mr. Harmon, you going to print this out?
Yes, Your Honor. May that 616A1? And can we, as soon as we're ready, put up B? Okay, Mr. Sims, we're looking at 616B now. You've already given the jury the orientation on that. What do these results reflect in your opinion?
This is an autorad developed from the locus D4S139. Perhaps we can brighten that up a little. That's pretty good.
Is this the best way to look at autorads, projecting them up on this screen?
That's not how we do it in the laboratory.
You look at it on a light box?
Yes, we study them under a light box,
Okay.
or over a light box.
Sure. Why don't you describe what you observed and what conclusions you drew from 616B?
Yes, from 616B, again, this is the locus D4S139. Again, the console lane has, in this case now, 4 bands. This is consistent with a mixture of the defendant's sample and Mr. Goldman's sample. And I will mark the bands again as I did previously in the console console lane, I'm marking in the pink or lavender the bands that are consistent with Mr. Simpson's bands. And now I'll mark them in his reference lane. And now I'll mark in green the bands that are in the console lane that are consistent with Mr. Goldman's bands.
Now, in this instance, Mr. Goldman's reference type and the corresponding evidence stain have two bands, is that correct?
That's correct. He has a two-banded pattern, which is the typical pattern in an RFLP, is a two-banded, but sometimes you'll see one, for example. And now I'll mark in green the bands of Mr. Goldman in his reference lane.
And I neglected to ask you this with regard to 616A, but Ms. Brown is excluded as the source of any of the typing results on the console combination. Is that true?
I didn't detect her band pattern in these auto-rads.
And the pattern you detected was inconsistent with her?
Yes.
Okay. May that be marked as 616B1, Your Honor? Can we put up 616C? Why don't you describe what's of significance in 616C, Mr. Sims?
Again, this is the same gel, but now this is the locus D5S110. Again, we see a pattern in the console lane that is consistent with the mixture of Mr. Goldman and Mr. Simpson. Again, the bands that are the strongest in that console lane correspond to Mr. Simpson's bands. The two weaker bands correspond to Mr. Goldman's bands.
Could you mark them with the corresponding arrows and colors that correspond to 616A1 and B1?
Yes, I'll use the lavender arrow to indicate the bands in the console lane that are in agreement with the bands seen in the defendant, Mr. Simpson's reference lane. And now I'll mark those corresponding bands in Mr. Simpson's reference lane. And now, switching to the green arrows, I'll mark the bands in the console lane that are in agreement with the bands in Mr. Goldman's reference sample. And now I'll mark in green the corresponding bands in Mr. Goldman's reference lane.
Okay, may we capture that as 616C1, Your Honor?
Yes.
Okay, we're looking at 616D now, Mr. Sims.
Yes.
Why don't you describe to the jury what you see on there and what conclusions you drew from the results?
Yes, this is now the locus D2S44. This is the final auto rat I'll show you today. This is a more difficult call on this particular lane with regards to the console, because you can see that Mr. Goldman and Mr. Simpson have fairly close bands as far as their upper bands are concerned, and I'll talk about that as I look at as I explain to you the console pattern. But I think you can see. I'll point with the lavender arrow at the bands in the console lane that are in agreement with Mr. Simpson's bands. And now I'll mark those corresponding bands in the lavender color in his reference lane. And now with the green arrow, I'll first mark, I'll go backwards a little bit here. I'll first mark the bands in Mr. Goldman's reference lane, here and here. And now we'll talk about the console lane, because this is a little more difficult to see. There's a band in this position, this lowest position in the console lane where I'm pointing now with the green arrow, that is in agreement with Mr. Goldman's lowest band. Now the difficulty arises when looking at this particular area right above the band that corresponds with Mr. Simpson's band.
The upper band.
The upper band. This autorad was reviewed by myself and then independently by a second reader. We felt that there was an indication of a band here, but we could not score that as a clear band. In other words, it's not clear and distinguished enough that we could make a determination that that is a band that's sitting on top of that one band. They're just too close to call, and it's just not clear enough. And so we did not score that as a band.
It's too close to what?
It's too close to the band that corresponds to Mr. Simpson's band in his reference sample.
Okay. And if what you see there really is a band, does that correspond to Mr. Goldman's other upper band?
Yes, it would.
Could you point to the area that you believe you saw some activity?
Yes, I'll point to it with the, perhaps I should use another color.
That's okay. We've described it as upper, so.
Okay, I'll point to it and mark it with the green arrow.
Okay. Can we capture that as 616D1, Your Honor?
Yes.
And actually, is there a fifth probing going on as we speak?
Yes, there's another film that if I get back today, I'll look at this afternoon.
Okay. Mr. Sims, why don't you go up and have a seat? I just have a couple more questions here. Mr. Sims, is there any question in your mind that the RFLP results that you've described to this jury represent a mixture more than one source?
No, there's clearly a mixture of DNAs in those samples.
And you've already described to the jury the significance of the relative intensity differences in the bands, and you can see what they are, especially on 616D. Is that true?
Yes.
What significance is there to the fact that you never observed more than 4 bands in the combined stain from the console?
That would indicate that we are seeing most likely DNA from just 2 individuals, not more than 2 individuals.
And just to make sure there's no confusion, because of the relative sensitivity of PCR with respect to RFLP, these RFLP results in no way undermine or contradict the PCR mixture results you previously provided to the jury. Is that correct?
That's correct.
Okay. Thanks, Mr. Simpson. Scheck.
5 minutes, or you want to take a break? It's up to you.
Let's take a break.
Your Honor, I neglected. We have a patch. I just wanted to complete his testimony by placing this patch
Well,
on.
why don't you ask?
Can we do that on
Go
the
ahead.
record?
No, why don't you do it on the record? Go ahead. And also, Mr.
Counsel
Harmon,
makes
let's say,
four votes.
right.
Okay, may the record reflect on the Bronco result board. I'm placing vertically to overlap the RFLP column on 303, 304, and 305, a label that says console mix 4 probes.
Okay. So noted. All right, ladies and gentlemen, we're going to take our mid-morning recess at this time. Remember all my admonitions to you, and we'll see you back here in about 15 minutes. All right, Mr. Simpson. All right, back on the record in the Simpson matter. All parties are again present. All right, Deputy McNair, let's have the jurors, please. Be joined by all the members of our jury panel. Mr. Sims, would you resume the witness stand, please? All right, Mr. Harmon has completed his direct examination, and Mr. Scheck, you may commence your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Mr. Sims, good to see you.
Good to see you.
Let's see if we can.
All right, you're going to put up again Peoples 172.
Yes.
All right. Got it?
And if we could look, just to clarify some of the facts here, at Peoples 172 and also the results board Peoples 260, to understand precisely what you have done here. Now, first of all, items 30 and 31 are depicted in the upper right-hand corner, is that correct?
Yes.
Of the Peoples 172. And those represent swatches that were made on June 14th.
Yes, that's my understanding, that those two stains were collected about June 14th.
On June 14th by Dennis Fung and Andrea Mazzola.
I'm not sure who collected them, but the date sounds right to me.
And each picture on this board, 29, that's the steering wheel you told us about, right?
Yes.
All right, that's the one with the 1.1, 1.2, and 4, correct?
Yes.
And the next picture over 33, another picture of the steering wheel, 29, 33 again, 22, 23, 34, the picture just showing 25, 26, 27. All those pictures were of collections made on June 14th, 1994. That's your understanding, correct?
That's my understanding.
And 293 is a carpet that was pulled out of the Bronco on June 14th, correct?
That's my understanding. The carpet was pulled out on that date.
All right. Now, samples 303, 304, and 305, those are the samples that you combined to do your new RFLP test, right?
Yes, 303, 304, and 305.
And they are depicted at the bottom right-hand corner here from the console.
Yes.
And those stains were collected on August 26th, correct?
Yes, my understanding is it's about that date.
Okay. Now, the results you got on the Bronco samples that were collected on June 14th are shown in the result board here. That's 30 and 31, correct?
Yes, I believe those are the ones, although 34, I think, and 29 were also,
I'm talking about the console.
oh, console, I'm sorry, 30 and
That's
31.
my question,
Yes.
right? The console.
Yes.
Now, 30, as depicted in the upper right-hand corner, from that swatch collected on June 14th, you got a 1.1, 1.2, 24, 25, correct?
Yes.
And that is a DNA typing that is consistent just with Mr. Simpson.
Yes.
And from that typing, there's, you can exclude Ronald Goldman and Nicole Brown Simpson.
Yes. None of their DNA shows up in that sample.
Okay. Now, the result from 303, the sample taken on August 26th, right?
Yes.
All right. Which is that one on the DQ alpha and D1S80, you got results that were consistent with Mr. Simpson, Mr. Goldman, and Nicole Brown.
That's correct.
And in theory, it's your understanding that 30 and 303 were taken from the same area.
Objection calls for speculation. This states the testimony.
Sustain.
Is it your understanding that 303 and 30 were supposed to be bloodstains in the same area?
Objection, that's vague, calls for speculation.
Overruled.
I remember we went through all this in May, and I think we got down to the issue of what are we talking about when we're saying it's exactly the same area?
I didn't say exactly the same. Same general area?
Same general area, yes.
Right?
I would agree
That's
with
what the reports you got indicated.
that. Same general area.
Thank you. Now, 31, okay, that's the second stain from the console from June 14th, right?
Yes.
And that's the one that you say has a DNA, a DQ alpha profile that is consistent with Mr. Goldman.
Yes.
All right, now. Your Honor, I'm, for the sake of, I don't know if it can be seen at the end, so I'll just try to put it on the middle. Now, Mr. Sims, 31,
All right, I'm sorry, Mr. Scheck, you just put up defense exhibit.
1309.
Thank you.
31 is the item, 30 and 31 are depicted here in defense 1309. Is that right?
Yes, the DQ alpha strips.
And in the upper left-hand corner, we see all the strips that were run that day.
Yes.
Now, you recall we discussed this, you and I, on cross-examination.
Yes.
And you would agree when I asked you those questions on cross-examination, the issues probably weren't so clear the way I did it that day with dots.
I thought it was clear.
Well, you thought it was clear. I apologize. But when Dr. Gerdes testified, he made points that were similar to precisely the points I was making with you when we visited this issue on cross-examination.
Objection, that's vague, no foundation.
It's argumentative. Sustain.
Argument.
All right. Now, you stated on direct examination one of the concerns that Dr. Gerdes expressed with respect to this 1.3 dot, correct?
Yes.
Now, wasn't one of the points that Dr. Gerdes made is that there was also evidence of the 1.3 dot appearing on the quality control sample 816 and the positive control in the same run.
Objection, that's beyond the scope.
Overruled.
Yes, he mentioned that in his testimony.
Right? And he took the position that scientifically, when your controls are showing 1.3s that shouldn't be there, it is improper to call a 1.3 that is also faint within a mixture. You remember he made that point.
Yes.
And your protocol, as we discussed when I cross-examined you, does say that if the quality control and the positive control fail or show unexpected results, that the procedure is to do it again.
That's what we would say, yes. In other words, if they show, I think the key word is whether or not they fail. In my opinion, they didn't fail.
I understand that, but you did not do this again.
That's correct.
However, and this is,
All right, Mr. Chair, just be careful, because that
I
easel
understand, I
has
think I've got
a, okay, it's got a limited capacity.
it.
All right.
1310.
1310, thank you.
However, on item 52, on board 1310, there was what you in your terminology call this 1.3 trace,
Objection,
correct?
it's beyond the scope, Your Honor. These are different samples.
Overruled.
Yes, it was called a C-/trace.
Right. And you also saw on one of the quality assurance sample in this run, what you called a trace of a 1.3?
Yes, I believe that's right, but I'd like to quickly check the note sheet for that day.
Would you accept my representation that this came from your note sheet? That's your
And that is my recollection.
And that on the positive control, it was a hint/trace?
Yes, in other words, there was more of a dot showing on this particular positive control than the previous one you showed me.
And that you decided, based on this data, to do it again.
That's correct.
And the 1.3 here, item 52 is a Bundy blood drop.
Yes, it is.
And if that 1.3 were a real allele, then that would indicate that there was perhaps more than one contributor to the stain you had there, or the blood.
Objection, 52 is beyond the scope of the record.
Overruled. But let's,
Yes, we're moving through it.
yes.
Yes,
Yes.
you recall that?
Yes.
Okay. And you did it again,
Yes.
and in your notes, even though it's not really visible on this strip, it was recorded very faint trace,
Yes, I believe that's correct when I rehided it.
and the rehive indicates that the film was developed for 22 minutes,
I believe that's correct, yes.
and your protocol is to develop them between 20 and 30 minutes.
Yes.
And would you agree that the amount of time that you develop them may relate to the intensity of the 1.3 dot?
Well, beyond about 20 minutes, there's really very little difference in those. It's mainly what happens in the first 20 minutes that's the issue.
Well, you didn't indicate on the sheets how long the original run of item 52 was developed.
That's correct. I consulted with Renee Montgomery later on.
All right. Now, to finish this up, you recall that Dr. Gerdes criticized your results by saying that it was inconsistent to call this 1.3 not real and without further testing to call the 1.3 on sample 31 real.
I believe that was his testimony, yes.
Okay. So those are some of the concerns that Dr. Gerdes expressed with respect to full rendition of his concerns with respect to sample 31. Fair statement?
I think that covers about everything.
Okay. And just so we're all clear, with respect to the console of the Bronco and the samples that were collected on June 14th, the only evidence from DNA testing that you have with respect to the console is that 1.34 finding that you and Dr. Gerdes disagree about on item 31.
Yes.
Okay. Now, with respect to the results on 303, 304, and 305, You recall that Dr. Gerdes expressed the view that the integrity of the evidence had been compromised by the way in which the Bronco was handled between June 14th and August 26th. Do you recall that?
That misstates the testimony. That's argumentative. That's not what he said. It's beyond the scope of the direct examination.
Overruled.
I believe I saw that in his testimony, yes.
All right. So you recall that with respect to his opinions about 303, 304, and 305, that was a concern of his.
I believe that was a concern, yes.
And do you have some familiarity with the way the Bronco was handled between June 14th and August 26th?
Objection, no foundation.
Sustained.
Speculation.
You can ask him if he took that into consideration.
Mr. Sims, from what you know about the way the chain of custody for the Bronco was handled between June 14th and August 26th, do you think it was handled appropriately in your forensic opinion?
Well, I don't know the whole history of how that Bronco was maintained. I don't know the whole history of that. I've heard that there were some,
Objection, that calls for hearsay.
Overruled.
Calls for speculation. No
Overruled.
foundation.
It's an expert opinion, counsel.
Please continue.
Overruled.
I've heard that the defense has raised some issues with regard to that. I don't know the truth of the matter on all these issues, no.
Object, that's not responsive. Move to strike. There's no foundation.
Overruled.
Mr. Sims, you heard Dr. Gerdes testify about it.
I heard him express concerns. I don't know what his basis for those concerns were, other than the general term chain of evidence.
You have no knowledge with respect to whether or not this Bronco was secured for further biological analysis between August 26th and June 14th in a way that would preserve the integrity of the evidence. You have no knowledge of that?
Well, I know what I see in the newspaper, and I know, for example, that I think 2 weeks ago you called a witness that addressed some of those issues, but that's what my knowledge is.
And you have not familiarized yourself then at all with what the history was of how the Bronco was kept? Is that what you're telling us?
Sustained. Rephrase the question.
All right. Have you, let me try it this way. Mr. Sims, in your forensic opinion, based on your experience,
Is it necessary for him to be down there at this point? Simply because we ought to use the microphones when we have them.
okay, if you could resume, I think it would save time if I keep the boards up, just so I
All right, go ahead.
Mr. Sims, to try to cut to the heart of it quickly, let me ask you to assume that between June 14th and August 26th, the Bronco automobile was put into a tow yard, that no records were kept as to who entered or left it between June 14th and August 26th, that unauthorized personnel were in and out of that Bronco automobile, that is, non-police personnel. They were in the seats, they were looking around the car. Would you consider that an appropriate way to preserve the integrity of biological evidence?
Well, I don't think that should be allowed. I don't think one should be allowed to come in and out of a car. I think that should be done by authorized people.
And that records should be kept as to who has access and doesn't have access to the vehicle if you're going to preserve blood evidence for future biological testing.
Well, when you put it in the context of records should be kept, I don't know. I mean, for example, there may be other tow yards that I've been involved with in forensic cases where perhaps just one person has the keys, so there's no record kept of all those things. But that should be controlled. Access should be controlled.
So your answer is yes.
Well, with what I added to that, yes.
Now, so basically, you have no basis for disagreeing with Dr. Gertie's judgment that the integrity of those samples, 303, 304, and 305, was compromised by the chain of custody procedures used in this case?
Sustain.
All right. You heard his testimony that he believed as a scientist that the chain of custody for these samples compromised the integrity of future analysis. You recall that?
Yes, I heard some of that.
And you're saying to us that you are really not familiar with the details of the chain of custody of the Bronco.
That's correct. I'm not familiar with those details.
And you have not endeavored to become more familiar with the exact details of how it was kept and who was in and out of the car.
That's correct.
And therefore, you wouldn't want to render an opinion on it because you don't have enough information.
Opinion about what?
Well,
I think I did offer the opinion of what should be done with that kind of evidence as far as securing it, yes.
All right. So your general opinion that it wasn't handled properly, but you don't know the specific details of how bad it was.
Well,
That's argumentative.
it is.
I'll move on. Now, just so we're clear, what you have done since we last visited is that you combined the samples that were found on August 26th, 303, 304, and 305, and you put them together. Is that correct?
yes, I've put them together.
Now, altogether, when you did the quantitations on all these stains combined, you came up with 72 nanograms of high molecular weight DNA.
Well, there was actually more than that, I believe, after, but some other tests were run in between. But it's about 72 nanograms.
About 72 nanograms.
Yes.
And looking at the results, you believe this to be a mixture.
Yes.
And the predominant contribution in the mixture is DNA that you say is consistent with Mr. Simpson.
Yes.
And that's something on the order of 3 to 1.
Yes, I would say it's somewhere in 3 to 1, maybe 2 to 1, but that's the right ballpark.
And therefore, the amount of DNA on the RFLP tests that is consistent with the profile of Mr. Goldman would be something on the order of 20 nanograms of DNA.
Somewhere in that area, yes. That's a reasonable approximation.
And that's why you had to put these probes, keep these probes cooking, so to speak, for 15 or 16 days to try to draw up the amount of DNA because there was comparatively a small amount there.
Yes, technically what's going on is that there's a low amount of DNA on that membrane, that southern blot that we made, which means that there's a low amount of radioactive probe that's binding, and so you have to let the film that's developing, you have to let that film go for a longer period of time. Usually we do these in a couple days, but for this type of sample, you have to let it go a week or longer to get those weak bands to show up.
And this is really at the, so 20 nanograms of DNA, that's really at the low end of your ability to detect, isn't it?
Yes, this is getting to the low end of the ability to detect.
Small amount.
Small amount.
Now, if we were to look at, give us some perspective. 1 drop of blood contains about 1,000 nanograms of high molecular weight DNA.
Yes, about 1,000 nanograms or 1 microgram, yes.
And in fact, you've seen estimates in the NRC reports and other places that some people put it as between 1 and 2,000.
Yes, it's in that area.
Now, if you, based on your quantitations, were to combine the amount of DNA that you got as a whole in 305, 304, 303, the August 26 collections, and for just the purpose of this hypothetical, let's also include the amount of DNA that came out of the swatches from 30 and 31. Are you with me?
Yes.
would you not agree that combining all of those together, all that from the console together, the amount of DNA would not exceed 100 nanograms?
Well, it might slightly exceed that, but it's around that ballpark.
Around 100 nanograms.
Around 100 nanograms, yes.
So that's 1/10 of 1 drop of blood.
Well, you have to remember that with a drop of blood, for example, if you're testing liquid blood, that's not the same as extracting DNA out of a stain's worth of 1 drop of blood. So you're not quite talking apples. You're somewhat talking apples and oranges there, but in terms of the ballpark, you're talking about, maybe getting 3/4 of that DNA out. So, you can figure it from that.
So, what you're basically saying to us is that maybe if you're just dealing with a pristine drop of blood, you won't get 1,000 nanograms, you'll get 750. Is that what you
Something
just said in English?
Yes, that's what I just said.
Okay. And if we were to, and I mean no disrespect for that, just summarizing it. And so if you've got about 100 nanograms of DNA and there's 750 nanograms in a drop of blood, can you give me that fraction quickly? That would be, what, about a seventh?
Something like that.
Okay.
Something like that, yes.
So certainly just reasoning from the DNA alone, the amount of blood, just looking at the DNA in the console, as you've said, is in the area of 100 nanograms of DNA.
Yes.
Objection, that assumes that it was all collected.
Overruled.
Well,
Overruled.
That's object to
Overruled.
the...
Overruled.
Oh, okay.
may I answer?
Oh, you actually overruled that speaking objection?
Speculation. It calls for speculation.
I overruled the objection.
It's a different one, right?
Ask your question.
Oh.
Next question.
Overruled the objection.
Can I finish my answer to that?
Oh, I'm
Your
sorry.
I
Never mind.
I thought you did.
I meant sustained, is what I meant.
That's what I thought you meant.
That's what I meant.
Okay. It's,
Here's the problem. The moment I start to think about something else, never mind.
I
Proceed.
thank you, Your Honor. Okay, now, you also were asked some questions on, withdrawn, I'll start this way. Now, you don't know anything about the order in which blood was deposited on that console.
No, I don't know the order in which the blood was deposited.
Are you familiar with the testimony of Dr. Baden in this case, that Mr. Simpson told him that he had cut himself on the evening of June 12th, I believe, and that he had gone into the Bronco searching for his cellular phone?
That calls for hearsay. There's no foundation.
This was his testimony. And with a small cut on the side of his finger, and had bled within the Bronco. He's familiar with that testimony.
Same objection. It calls for hearsay. There's no foundation.
Overruled.
Misstates the testimony.
Overruled.
No, I really wasn't interested in the doctor, is it Baden, how you say it, in his testimony? I don't recall that. I don't recall his testimony on that issue.
But, all right, just looking at it then from the point of view of forensic DNA expertise that you have, ask you to assume that there was an initial deposit of Mr. Simpson's blood on the Bronco from a small cut. And I ask you further to assume that at a later point in time, there was a second deposit. All right? Have that hypothetical?
Okay.
And if one assumes, for the sake of argument and for the sake of this hypothetical, that the blood stains of 303, 304, 305, all right, were all present also on June 14th, all right? Just asking you to say it. To assume both of these There's no question, just for the purpose of this hypothetical, that everything that was in August 26th, right, that was found there, was also present on June 14th. Just for the purpose of this hypothetical. Are you with me?
Okay, on June 14th versus
Right.
August 26th. Okay, those are the two collection times.
Right?
Okay.
But if we assume that on August 26th, the finding, the stains there, 303, 304, 305, were also present on June 14th, but somehow they were missed, okay?
Okay.
Your conclusions with respect to mixtures are not inconsistent with two deposits at two separate times.
Objection. I've seen a proper hypothetical. This stage of testimony, there's no foundation for that.
Overruled.
Okay, I understand the hypothetical, but now give me the last phrase, please, the question.
In other words, your findings here of mixtures are not inconsistent with a contribution of Mr. Simpson's blood at one point in time, and then a subsequent contribution of blood from Mr. Goldman at a subsequent point in time.
That's correct.
And in fact, based on all the testing that you did, most of the blood, most of the DNA that you extracted from that console is consistent with Mr. Simpson.
He is, in the samples that we looked at, he would be consistent with the main contributor of that DNA mix.
Something, when you combine 303, 304, and 305, something on the order of 3 to 1.
Yes, that's a reasonable figure, something like 3 to 1, maybe 2 to 1.
Now, finally, you have continued testing. Are you still continuing testing in this case?
Well, as I mentioned, there is another autorad that I'd like to look at this afternoon, another probe, another one of these autorads that we're developing.
Have you tested item 1, the speck on the door that was first observed by Detective Furman?
Sustained.
Do you have DNA samples from the handrail? Have you tested that?
Objection. This be on the scope.
Sustained.
Excuse me for 1 second. Approach the bench for just 1 minute. Scope.
Proceed.
On the scope, I don't want to ask a question.
All right, with the court reporter, please.
Take just a second.
All right, thank you, counsel. Proceed.
Now, Mr. Harmon asked you some questions on direct examination about these RFLP results allaying concerns that Dr. Gerdes expressed with respect to cross-contamination. You recall that?
Yes,
He asked you that question very generally, didn't he?
yes.
Now, these RFLP results only deal with samples 303, 304, and 305.
That's correct.
These RFLP results do not address any issues of cross-contamination with respect to the Blundy blood drops 47, 48, 49, 50, and 52.
Objection, that's vague, Your Honor.
Overruled.
No, these results relate to these samples.
All right? They don't relate to any problems of cross-contamination that occurred in the evidence processing room on June 14th when Colin Yamauchi examined the Rockingham glove.
Objection, it's beyond the scope.
Overruled. But you can generalize this.
I just only have 2 or 3 more questions just to show what it doesn't concern.
It also misstates the testimony.
Overruled.
The question again,
The
please.
question is, these RFLP results don't address the issues of cross-contamination that have been raised by Dr. Gerdes concerning Colin Yamauchi's handling of the Rockingham glove in the evidence processing room on the morning of June 14th, right?
I'm trying to recall what issues Dr. Gerdes specifically raised about those because I don't recall seeing any issue with those particular samples.
Well, you don't recall his testimony about that? Is that what you're telling us?
I don't recall the details of his testimony about those particular samples.
You don't recall his testimony about Mr. Yamauchi? All right. You don't recall it? Is that what your
Well, I said I
testimony?
don't recall all the details. When you start talking about issues, you're putting a plural on it, and you're
Mr. Sims,
implying there's some.
Mr. Sims, even if you can't recall all the details of what Dr. Gerdes said, you don't believe that these RFLP results on 303, 304, and 305 have anything to do with it?
Objection, it's argumentative.
It is.
Do you believe they have anything to do with it? Do
Well-
they address those concerns about cross-contamination?
I think in the narrow sense of your question, no. The answer is no, they don't address that.
Thank you. Now, Dr. Gerdes gave extensive testimony concerning a study he performed of contamination at the LAPD laboratory and the efficacy of controls and sample handling procedures used at the LAPD laboratory. Are you familiar with the fact that he testified about such a study?
Objections beyond the scope of direct
It's my
examination.
last question in this line.
Yes, I'm aware that he presented that.
You didn't read that study or review his data, did you?
No, I did not.
Now, Your Honor, and we just think about it, but I actually think I'm finished. Your Honor, I have no further questions, but I would request, based on what we've discussed, that this witness be subject to recall on another matter.
All right, no, Mr. Sims, we know where Mr. Sims is, and he knows how to get to L.A. All right. Mr. Harmon, do you have any redirect examination for Mr. Sims?
Just taking up with that last point, Dr. Gerdes' study about LAPD, do you recall that Dr. Gerdes was unable to recount the history of from the sample collection of 303, 304, and 305 when Mr. Clark asked him to recite that to the jury?
So far as he said, he doesn't remember his testimony completely.
No, I did read that part of the testimony. I did review that particular part of the testimony regarding who collected the samples with regards to 303, 304, and 305.
And based on reviewing his testimony, do you recall that Dr. Gerdes made no specific technical criticisms of your PCR results from 303, 304, and 305?
Yes, my recollection in his transcript was that there was no specific criticism of those PCR results.
Now, Mr. Sims, your crime scene collection days have long passed, is that right?
I haven't been to a crime scene or a vehicle, that sort of thing, in about 5 years now, over
And
5 years.
Mr. Scheck asked you about the appropriate way to preserve evidence and keep logs of who has access to evidence. Do you recall that?
Yes.
Now, and you said that's not the appropriate way to do it.
Well, I just said that access should be controlled. I think that was the gist of my response.
Now, the failure to keep a log of who went in and out of a car, if anyone went in and out of the car, that's not going to change the types of the RFLP results that you presented to this jury that are consistent with Mr. Simpson and Mr. Goldman, are they? Is it?
Beyond scope calls for speculation.
Oh, well.
No.
And allowing people to go into the car to look around, unauthorized people, if that actually happened, that alone is not going to necessarily change the PCR or RFLP results from 303, 304, and 305, is it?
That's correct.
What you have presented to this jury is the results of your testing, DNA testing from various samples that are provided to you. Is that true?
Yes.
Is it unusual for you not to know the history of a sample in a case?
No, it's not unusual to not know the complete history of a sample in a case.
In fact, given the way these violent crimes often occur, some history of the sample is frequently lacking when you do your testing. Isn't that correct?
Well, yes, that's true.
Let's just I'll give you a hypothetical and so we can illustrate this. Let's assume we have a female brutally murdered, signs of sexual assault.
Objection. Calls for speculation irrelevant beyond the scope.
Oh, well.
Signs of sexual assault, evidences of vaginal swabs, parents' seminal stains on clothing are all collected and sent to you with reference samples. Are
Renew
you
the
with me so
objection on
far?
relevancy grounds.
Oh, well.
Haven't
Yes.
heard the question yet.
Now, that's not an unusual case to be presented to you in the DOJ lab, is it? Evidence like that.
No, that would be a typical or not unusual.
And it's not unusual for you to perform tests on those samples, isn't that true?
Yes.
And in cases like that, you have frequently identified people as the source of sperm in apparent sexual assault murder cases, isn't that true?
Yes, for example, we've used the DNA to say who could be a potential source of that particular semen sample.
Now, when you do those testing, or that testing, based on the test results alone, you can't necessarily tell whether the sex act that produced the sperm occurred before the homicide, can you?
That's correct.
You can't necessarily tell that the sex act that produced the sperm occurred during the homicide.
All right. This is irrelevant.
We're about to become irrelevant.
About two more questions, they'll be totally irrelevant, Your Honor.
Proceed.
You can't tell that the sex act that produced the sperm occurred in any relationship to the violence that caused the homicide, can you?
That's correct.
And last question on this point, you can, for example, you might be or the sperm that you produce might be someone who had sex with a person who's been murdered where the sex act occurred after the homicide.
Possible.
It's not that actually results.
All right, let's move on.
Now, Mr. Scheck asked you a series of questions about people having access to the car and coming into the car, and I just asked you some questions about those things wouldn't necessarily change the type of the result of the DNA that was there. Do you recall that?
Yes.
Now, in order for one person to have produced the RFLP results or the PCR results that you detected on that console, there'd have to be something terribly wrong with that person, wouldn't there?
Objection. Vague.
Sustained. Vague.
Based on your DNA results, in order for one person to account for the DNA results from 303, 304, 305, both individually and in combination, there'd have to be something terribly wrong with that person, wouldn't there?
Sustained.
Would there have to be something terribly wrong from one person if one person were to try to account for all of the results from 303, 304, and 305?
Oral.
Yes, it would be some sort of genetic anomaly.
In what sense?
Well, because you see more what we call alleles or types than you would from a single individual.
Okay. For example, you've already described the significance of seeing 4 bands, 2 of higher intensity and 2 of lower intensity.
Yes.
Are you aware of anything in the literature where one person could have 4 bands where they're of different intensities
Well,
from these probes?
the sort of thing where we might see that would be on, for example, somebody who is transfused or something unusual like that.
Well, to just add to the mystery a little bit, if in order for you've paired those results. You've paired some of them that are consistent with Mr. Simpson by relative intensity and some that are weaker than Mr. Simpson, and they're consistent with Mr. Goldman. Is that correct?
Yes, the intensity patterns, the band intensity patterns pair up between those two individuals.
In order for another person to account for depositing, let's say, the weaker set of bands, they'd have to match Mr. Goldman's type, wouldn't they?
Yes.
Now, the last point, or I think it's the last point at least, Mr. Scheck asked you about the console mixture results that you've described to this jury, 303, 304, and 305, both PCR and RFLP. And you said they're not inconsistent with 2 deposits, the results alone. You recall that?
But the RFLP results are consistent with 2 depositors.
I didn't speak clearly enough. Are they, I think you told him they're consistent with 2 separate deposits, having come at 2 different times.
Oh, as far as the order of deposition?
Yeah, or whether they were simultaneous or at different times.
Well, I said I could not rule out that possibility, yes.
Now, is there something about the amounts of DNA in those samples that tells you that it's highly improbable that that occurred?
Well, it's hard to say too much just based on these amounts of DNA in those particular samples. I have no reason to suspect that they are from different times, but there's nothing clear to me one way or the other.
Would you say that the amounts that would be represented from, say, Nicole Brown, who is not detected in the RFLP testing, what can you tell us about that?
Well, when you enter the point now where you're talking about 3 different people's blood on a console in a vehicle, I mean, forensically, that seems very significant to me. I mean, it just seems unusual that you would have 3 different individuals bleeding or their blood present inside a vehicle in that kind of a location. That, to me, is the significance.
May I have a moment, Your Honor? Mr. Sims, Mr. Scheck never asked you about 293. 293, you're aware of the history of 293?
My apologies.
Asked about
293.
293.
Yes, he asked me about that, and I discussed a little bit about how the carpet was cut out and then later sampled.
Okay. And that was done at the earlier date rather than the later date. Is that your recollection?
My understanding is the carpet was cut out at the earlier date.
And the types that you found on the carpet are consistent with, are the types that you found on the carpet consistent with what you detect as the possible presence of Nicole Brown on 303, 304, and 305?
Are they consistent? Yes. In other words, her type that was found on that sample is consistent also with what was seen in the Bronco console.
And finally, I'm going to ask you a question about 31 and 30 and 303 and 304 and 305. A chance to look at those results? Are those results consistent with Mr. Simpson having injured himself during the brutal murder of Nicole Brown and Ronald Goldman, returning to his car, that Bronco, with a right-handed glove that bore their blood commingled with his blood from his injured left hand, and somehow that item having come in contact with the console?
Objection calls for speculation.
Sustain. Foundation.
I'm going to ask you a question then about whether the question is, are your results consistent with the following scenario? You know what Mr.
Haven't heard the question yet.
You're familiar with the testimony that Mr. Simpson had a cut on his left hand.
Well, I mentioned that I hadn't heard Dr. Bodden specifically talk about that. I'm aware from other issues in this case about the cut on the hand,
On the left hand.
on the left hand, yes.
You know what his DQ alpha type is.
Yes,
You know what his RFLP type is from all the tests that we've done.
yes,
And you're familiar with the fact that the victims in this case, their reference samples were provided to you for typing.
yes,
Okay. You're familiar with your typing results from the glove, number 9.
yes,
Okay.
Overruled.
You're familiar with where all the stains were found on the console. We've just had the photo board up there. Is that right?
yes,
Are the PCR and RFLP results that you produced, your lab produced from the console, are they consistent with Mr. Simpson having injured himself while brutally murdering Nicole Brown and Ronald Goldman?
No foundation.
Sustain.
Are they consistent with Mr. Simpson having injured himself at or about the time someone brutally murdered Ronald Goldman?
Sustain.
Objection and moves to
Sustain.
strike. Ask for an
Sustain.
instruction if he persists.
Mr. Sims, let's go back to the same question about the console. Are all of your console DNA test results consistent with the glove, item number 9, having Mr. Simpson's blood on it, that glove being in the Bronco, coming into, and having the victim's blood on it as well, and that glove coming into contact with the console and transferring portions of all 3 participants' blood onto the console?
Objection. No foundation.
Sustain.
Calls for speculation.
Mr. Sims. Mr. Sims, you know what the glove results that your lab produced suggest a mixture consistent with Mr. Goldman, Mr. Simpson, and Ms. Brown. Is that correct?
Beyond the scope.
Overruled.
Yes.
I want you to assume hypothetically that that glove was brought into that console or into that Bronco, and that glove transferred some of the blood from the glove onto the
Cause for
console.
speculation.
All right, ladies and gentlemen, we're going to take our recess for the morning session at this time. Remember, all my admonitions to you, don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case as far as the jury is concerned, and counsel will stand in recess until 1 o'clock. Mr. Sims, you may step down. You're ordered to come back at 1 o'clock. All right, we'll stand in recess.